my name is not on here, but my name is Elizabeth Vincent, and I am a technology attorney. I've spent the past 5 years in-house with bigger technology companies in Indianapolis, negotiating contracts both for licensing their technology out to other companies and having different developers and companies perform technology development and licensing software to us. So that's my main area of expertise. And so kind of a similar situation to Cash. I ran into the awesome guy in the pink handkerchief and hat back there at a Powder Keg event, and he read my name tag and it said legal on it, and we got to talking and thought that it would be a great introduction for some of you maybe and refresher for probably a lot of you on what intellectual property is and the rights that come along with it, and some of the things that you need to look out for working in the technology industry, either hiring people to do development for you or if you're doing development for another company or another person, to make sure that you know and are being compensated appropriately, or you are compensating appropriately based on if you're going to continue to own what you do or you're going to sell what you do and transfer it for that compensation, or you're going to license it. So when you're taking these types of jobs, you really understand what is happening. So this is kind of what we're going to cover today. The way that I thought we would kind of do it is I'm going to ask you guys these questions, and then we'll talk about the answers so that you get to interact a little bit, and I can see a little bit more of what level you guys are at on these issues. So we're going to talk about what intellectual property is, the rights that go along with it, the ownership component that I just mentioned, licensing, and the takeaways for when you're looking at agreements and when you need to talk to counsel. So first of all, what is intellectual property? Can anyone tell me? Yes, you in the back. Patents, yes. IP includes patents. Yes. Trademarks, yes. Copyrights, trade secrets. So, intellectual property refers to creations or works, as they call them in the legal world, of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images used in commerce. So you have your patents over here. There are different types of patents that I'm not going to go into, but one of them is on the toilet paper roll, which I think we're all very thankful for. And then you have your copyrights that protect your books and your trademarks that protect your images that and your logos that are associated with companies or works at a very high level. These are the types of intellectual property that most relate to things you would be doing in development. Some software is patentable, some of it's not, and then there's a lot of copyright rights that can go along with the code, and then if you're going to name it and sell it or license it, the trademarking will be important. All right, so the next question is, what are the intellectual property rights? A lot of times these are called like a bundle of rights, or the things you get to do with something that's considered intellectual property. Does anybody know? All right, so the first one is to use it. So use can encompass a lot of different things, but basically it's any type of use. So if you're going to run the program, if you're going to offer people to come see a movie, if you're going to use the intellectual property in any way, that is a right. And there are exceptions to having that as an exclusive right, but in general, any sort of use is a right of the intellectual property owner. The other ones that are usually called out are to copy the work, create a derivative, which is like using the work to create another work, to distribute it, sell it, display it, perform it. If you go see a play, they have to get rights in that play in order to perform it, even if they're not using any of the original actors or singers or music or whatnot. If they're performing the script, that's still copyrighted, and one of the rights that goes along with copyright is performance. So the next question is, who owns the work? Does anybody know who owns the work when it's created? Yes. The one who paid for it. Does anybody agree or disagree? Disagree? The author? You guys think the author owns it? Can we get like a poll? So, the usual answer in legal situations, it depends. So, generally, the author of the work owns the work. They're considered the creator, and they have the exclusive rights to what they have created. So all of those rights that we just went through as far as using, copying, distributing, those are all their rights. So if you just do something on your own with your own equipment in your own time, you are the owner of what you've created. If you paint a painting, if you write some code, if you create a dance, all of that, it's all yours. So where it gets tricky is a concept called work for hire. So there's a concept called work for hire, and it's usually spelled out in agreements, although there's some law that attaches because of certain circumstances that I'll talk about in a minute. But most companies who are going to hire someone to do development work for them are going to include a work for hire clause in the agreement. And this essentially means that they're paying for you to do the work, and therefore the work is theirs. Oftentimes it'll say that you're at that point in time assigning the work, and if for some reason that assignment isn't legally valid, then you agree to assign the work and to sign any sort of instrument that they would need in order for them to have ownership of the work. So if you're the developer on this side, you need to understand that all of the time and effort that you're putting into this is going to be for the paycheck that you're currently receiving, that it's not going to be something that you can parlay and sell or license in the future. It belongs to the company that you're developing it for. As a company, you want to make sure that your contract is very clear that all works are works for hire, and that you have enough mechanisms in your contract to get that work from that person in case they decide to leave with it or not give it to you, or to try and sell it themselves, sell it to the highest bidder or license it themselves. Yeah. Yep. Yeah. So the question was, does that apply if someone is designing a logo for you or designing a website for you? And it absolutely does apply. So you have several rights that are associated with the logo, as far as you have a copyright in the artwork. You probably have a copyright to an extent in any sort of language that's used in the artwork or the logo. And then the logo and the itself, or the logo and the trade name, can be trademarked. So once again, whoever creates that work is the owner, unless it is either explicitly spelled out in the contract that the company who's essentially commissioning the work is the owner, or if the company can prove that it meets a certain set of circumstances. Some of those circumstances are that the employee or the contractor is using the company's equipment. They're doing it on the company's time when the company's paying for them to be working. It's part of their normal job duties. Things like that are the factors that a court would take into consideration if a dispute arose on whether it was a work for hire or the developing party still owned it. Okay, so then the other thing that I want to talk about is licensing. Is anyone familiar with licensing? Exactly. You sell your intellectual property rights temporarily to someone else to use. So we have a couple different things that you can do with IP rights that we're going to review really fast. You can develop it and own it. You can develop it for someone else and they'll own it. You can pay for it to be developed and own it. Or you can pay for it to be developed and not own it if you don't follow appropriate procedures. Or you can license it. Either license it out as the owner, or you can license it in as someone who wants to use the technology but doesn't want to develop it in-house or doesn't have appropriate rights to the technology already. So most of the transactions that are happening between companies right now are licensing of technology. And when you're looking at a licensing agreement, you're looking at several different things. It's essentially the license grant is going to tell you who can use it, what it is, when they can use it, where they can use it, and how they can use it. So a license grant gets very specific and should be very specific because if you just say, company XYZ has a license to use this, then there's not very clear restrictions on how long they can use it, where they can use it, and if they can, sub-license it, anything like that. So the who is usually going to specify the licensee. It may specify like a company's subsidiaries or affiliates in certain situations, and it's going to tell you whether it's exclusive or non-exclusive. So an exclusive license is usually much more expensive than a non-exclusive license because you are the only entity that has a right to use that intellectual property, including the owner. So if you have an exclusive license, even the owner can't continue to use the IP unless it's spelled out in the contract. What is it? Is it software? Is it a trademark, copyright, patent? What are we licensing? And this, again, is important to be very specific about because there are usually a lot of components that come with a product. So what part of it are they licensing? When? Is it for a year? Is it for a day? Is it forever, which is called a perpetual license? Where? United States, worldwide, Mexico, Indiana, in main event. And then how can they use it? Can they copy it? Can they sell it, sub-license it, create derivative works? All those rights that we talked about earlier in the bundle of rights is what can they do with it? So these are things to be aware of when you're developing work and when you're talking to employers or to clients about the way that ownership and licensing will work. You want to make sure that these are all really clear. So the takeaways are that intellectual property is valuable and it's also protectable. If you, like I said, if you're having something developed or developing something for someone or for a company, you need to be sure that it's very clear in your agreement who owns the work and what the work is, and if there are any licenses that are going to go along with the work in that situation. Most importantly, from my point of view, consult an attorney when you're entering into an agreement, whether it's an employment agreement, a work for hire or a contractor agreement, professional services agreement. licensing agreement. These are incredibly complicated agreements, and they're litigated on a regular basis. And I would hate for you to have to spend a lot of time and money in litigation, or trying to resolve a dispute over something that you already spent a lot of money on or spent a lot of time on developing or having being developed. I also, which is how this conversation came up, want to warn you about infringement. So if you are doing one of the bundle of rights, if you're using, copying, selling, distributing someone else's intellectual property, it's called infringement. And if you aren't aware that you're doing it, that becomes difficult because there usually is no knowledge requirement in the law. So you want to be very careful about the code that you're using, if it's open source, if you're, following up on somebody else's work. You want to make sure that you understand the rights that the person before you had and the rights that they're allowed to give you before you start messing with it. Because just because you didn't know doesn't mean that you can't get in trouble. And an attorney, if you're working with an attorney, will help you put the appropriate provisions in the agreement stating that the other party has all of the appropriate rights, and also stating that they'll indemnify you, which means they'll protect you from lawsuits if they're lying or if they're wrong. So make sure and consult an attorney before taking any actions that may violate another party's IP rights. I definitely got to time, so I apologize. But if you have any questions, please feel free to reach out to me. The company's name is EV Solutions, but all of our tags are EVSO Consulting. Please feel free to schedule a meeting on my website or send me an email. I'd love to talk to you guys.